Good morning.
Of jail. You got another case now.
Say again?
You have a new case now.
Yes.
We filed a fugitive case against you. I don't know anything about it. All I know is that you have an open DWI with us. You have a prior fugitive case, and now it's another fugitive case.
They were both at the same time. Oh, yes.
Let's find out. I don't know. Tell me.
So Judge Fleischer, he's wanted out of Beauregard Parish, Louisiana for home improvement fraud. At this time, the state's asking for no bond based on the fact that he has a prior fugitive case, which he was granted 2 bonds on, and both were revoked. They were $25K and $65K.
We gave him a $65K bond, and he made it, and it got revoked?
It was dismissed. The case was dismissed by Louisiana. The DA didn't even take the charges.
Oh, we did file a dismissal on that.
Yeah.
For whatever reason it was.
The whole time, that's why, because you guys asked me to report whenever it was dismissed. And we just I had an attorney after I gave him my attorney's number. She fought back and forth, and the DA didn't even accept the charges. That's why it was dismissed.
Judge, I would argue that shouldn't be considered against him if that's the case.
He still has a prior fugitive case, right? I mean,
well, just talking about this one, he's saying he had no knowledge of the filing of this case. This is called a home improvement fraud. It sounds like from talking to him, this is leaning, my argument would be this is leaning more towards a civil matter than a criminal matter. He works as a construction builder. He has his own company, my understanding. He is on the minority builders list for Harris County. And so he's got a company. It sounds like this might be
cases where a guy takes money to build a house or make improvements, and then they boom, just take off?
No, what happened was it was a licensing. Oh, I'm sorry.
It was a licensing. He's talking about a licensing issue. I don't want to get into the specific facts of that, Judge, but on these construction projects, there's always 100 lawsuits that could pop up, and some of those can turn criminal. And so he is looking for an opportunity to fight that over there. He's got a lawyer by the name of Jeanette in Louisiana that's going to help him resolve that situation. His DWI here is being resolved by a Mr. David Brazil. All we ask is for him to be able to post a bond so he can go figure out Louisiana, turn himself in, or post a bond out there and resolve the case instead of having to wait for Louisiana to come get him.
Judge Fleischer, just based on his warrants that were issued on the DWI case local here in this court, and then the 2 warrants issued for his last fugitive case, and then further criminal history out of East Baton Rouge, Louisiana for like looting, burglary,
oh no, that's not me.
Property, damage for property, possession of stolen property, MJ felony, theft, monetary instrument abuse, battery, child endangerment.
Judge,
that's not me.
Are we sure we're talking about the right Kareem Williams?
Kareem Williams.
That is what Mr. Stan Clark told me. I can double check.
Yeah, that is definitely not me.
There's 2 Williams.
Regardless, I'm going to tell you that the first time I gave you a bond here, I tell you the same thing I tell every single person, that I give you one opportunity. When you pick up multiple fugitive cases, I'm not going to continue to give you bonds on multiple fugitive cases.
I really didn't know about this one, Judge. It's not a court issue that I win.
The first time I tell you, look, I'm going to give you a bond now. If you get another case in the future, it's not going to happen. We don't continue to give bonds on multiple fugitive cases.
It's a warrant that I never received. It's an original warrant that I never knew nothing about.
How do I know that?
Judge, if I may, those previous fugitive cases that we're talking about, are those here in Harris County? Because I didn't see anything pop up here for Harris County on that. So you've never given him an opportunity. He's never messed up in your court, correct?
I see 2 prior fugitive cases, and she's telling me that I gave him 2 different bonds on the fugitive cases.
You're talking about the DWI.
Well, no, he's had bonds on the DWI. Those were revoked. And then he had a prior fugitive case that was filed in 2019 where he was granted 2 bonds, and those were also revoked.
But is that here in Harris County, or is that
in Harris County?
And
okay.
He's on the lam for the DWI, right?
Okay, so
Did he have a warrant for his arrest on the DWI when he got picked up on this case?
let me see. I believe I saw.
No,
there was a warrant issued on July 31st of 2019 for your DWI.
Did he ever post bond on that and get out? Or was it in warrant status the whole time and we just picked him up on this one?
And the other charges that you said, that's not me.
I'm going to delve into what the other stuff she's talking about. How'd you get on this team?
I came in.
You came in yourself?
I came in myself to post the bond.
DWI?
Correct.
Judge, my client's telling me he came in himself to resolve this issue on the DWI. It wasn't picked up, is what he's conveying to me.
Looks like the DWI was from 2019. Jeff Ludwig was the lawyer on it and filed a motion to withdraw, and the case has been open since that time.
And here's the problem, Judge. I don't want to speak too much about that DWI case, but because my understanding is David Brazil is an attorney who's handling that case. And so I don't want to jump in and talk too much about something that somebody else is handling.
Anyone
You
on
don't
it?
have a David Brazil?
I just retained Mr. David on Tuesday.
No, the last thing I have on that is a motion to withdraw filed by Jeff Ludwig in 2019. Nothing has happened since that time.
Okay.
So,
Since 19, you're saying?
I mean,
Yeah.
look,
No, I get you. I just thought he had somebody ready to go on that. Okay. Would you consider a bond? Would you consider putting some skin in the game and he knows he's gonna lose it if he doesn't?
he was on the land for this DWI. You're a flight risk. You were on bond for this DWI since 2019. You took off. We haven't seen you since 2019. And the only reason we have you here now is because you have a home improvement fraud case from Louisiana.
I came in to pay for my DWI, you know.
When?
That's why I'm here.
Oh,
I'm not making.
that's why you're here now.
I'm really not. But I'm just asking just to be able to go take care of this. Like I really do. I'm trying my hardest. You know, I just lost both. I lost both of my parents. When I got in that DWI in 19, my grandma had just died in a house fire. It's not an excuse. It's not.
Specifics.
Oh, yes. So,
Judge,
I'm just-
any amount that you would consider, would afford him an opportunity to do so? He would know the risk, and it would be a risk that would guarantee that he does what he's supposed to do.
and would not do the same mistake again.
Had your DWI open since 2019, and you've been out with a warrant for your arrest since 2019. The only reason you're here with me now is because you picked up a felony out of Louisiana
That's
that
all
you haven't
That,
make bond. So I think you are a flight risk. If I give you a bond, you will take off on me because I gave you a bond in the DWI, and the last time I saw you was in 2019.
just my parents that died going, I'm not making.
And I'm really sorry for your parents,
Give me another chance. I'm not.
but
If you give me a chance, I'm not gonna mess this up.
I gave you a chance. I've given you 2 chances. Fool me once, shame on you. Fool me twice. Right.
Here's what I'll do, Judge. I was just appointed on this case today. There has been some criminal history thrown out that I was completely unaware of. Let me do my homework on this and reapproach with a better argument.
Can we
after a couple
appoint
days.
Ricardo in the DWI as well?
It's in another court.
It's here.
No, it's here.
It's here. It's
I thought I saw court 2.
No, it's with us.
Court 5. My concern was that you told me there was another lawyer already on it. Yeah, Green Williams.
Oh, it is something.
And so I just asked for a short reset to make a better
As
argument.
long
for
as you
him.
want.
Okay.
So here's the deal now. You have 2 different options. You can either waive extradition.
He's already done so, Judge, is my understanding, yesterday. This clock is started.
Okay. Yes, but I'm going to say this, though. If they gave him a PR bond on this, ixnay on the PR bond A.
On the DDA?
Yeah.
You're going to do something on the DDA?
Uh-huh. It's been open for 4 years, and he's been on the land for 4 years.
So am I getting, I don't want to argue on that one until I'm appointed.
I'm gonna reach out to them. So can you please? You are,
You
okay.
don't have anybody else on?
So let's do this. I'll have you guys going back, talk about it, but I can't in good conscience give him a PR bond again. When we did that and he took off for 4 years, no, it doesn't work like that.
Understood. I'll talk to him.
No catch and release.
Okay.
Okay?
Let me talk to him. All right, Mr. Williams.
Just please don't send him down.
Yeah, let me talk to him.
All right.
Mr. Williams is out. Okay.
I've signed Senegal's dismissal so that she can go.
She's on her way over there to get the GPS
Okay, great.
appointment set up right now as we
Okay, so
speak.
Ramon Sanchez, you said?
Well, we brought out Mr. Williams first. I guess we can speak about Mr. Williams. It's a DWI case as well in this court.
There's a motion on the local.
On the local
What do you
DWI.
want to do?
So this is the one where you were talking about.
Yeah.
Would you consider a $1,000 bond?
No, it's at 2,500, man.
Is it at 2,500?
2,500.
But it was a pretrial bond. You didn't
Yeah,
have-
I'm just, okay, so what I'm gonna do is I'm no PR bond,
Okay,
and I'll leave it as is at the 2,502,
okay.
and that's it.
Yeah, that'll work. Okay, let's do that. They'll leave it at, you're gonna have to pay a bond, but it's.
If your bond is at 2,500, I can't in good conscience give you a PR bond when you've taken off for 4 years. We gave you a PR bond, you've been gone for 4 years, and you have a fugitive.
02 on the DWI. Once you post that, your clock starts on the 14 days. So he's providing you a bond. I think it's good. We'll take it, Judge. Thank you.
Okay. All right.
Appreciate it. All right.
Episode, we're heading back to the Harris County Criminal Court in Houston, Texas to once again review some probable cause hearings decided by Judge David Fleischer. In these cases, Judge Fleischer decided that there was not enough evidence to support the criminal charges brought against the defendants. This episode is part of an ongoing series dedicated to helping our viewers better understand how probable cause plays out in an actual courtroom, especially when decided by a reasonable and impartial judge. February 21st, 2025, Edward Love Jr. and Edward Love III were charged with evading arrest or detention based on allegations that they ran away when approached by a police officer.
Good morning. Happy Friday. Michael Love, come up.
It's two, Michael Love and Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up. Who's Junior? And you are? The third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, officers dispatched to First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible burglary progress, with fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to comply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both contained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, Your Honor.
Cops never tell them to stop.
Exactly.
And what are they doing wrong? I guess, I mean, what is this, Minority Report? You know what I mean?
I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand? I'm going to
Fleischer determines that there is no probable cause to support the charges against the Loves for evading arrest or detention under Section 38.04 of the Texas Penal Code, which makes it an offense to intentionally flee from a peace officer who is lawfully attempting to arrest or detain an individual. The statute requires that the person know that the pursuer is a police officer who is actively attempting to detain them, typically communicated through a clear directive to stop or otherwise submit to authority. Now, because neither Mr. Love Jr. nor Mr. Love III was ordered to stop by the officer, this essential element of intentional flight from a lawful detention was never triggered, and the statute would not apply in the absence of a communicated attempt to detain. Accordingly, the state dismissed the charges on the same day. Before we continue,
I had a guy charged with felony that was arraigned this morning, but he's on your docket later in the week, and I was hoping just to get it done so we can.
Of course. Let's do it.
Okay.
Do you have the cause number?
I do, 255-9578. He's already got conditions from Judge Simons. Where'd he go?
Judge Simons.
Yeah,
Okay.
Judge D. Simons. And so it's my understanding there's no alcohol. He's got a device also already, I think, or at least we can double check.
All right, sir. You are Mr. Cutler.
Kubler, yes,
While intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So he's also charged with abandonment. Is it out of the same transaction?
Yeah, we had a long discussion with him this morning.
On April 11th, 2025, an officer was dispatched to an unknown accident, and noticed a vehicle, a pickup truck, illegally parked in the front yard of the residence. There were fresh tires, skid marks, a broken wheel, and axle visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with the complainant, and then it said that the damage to the Jeep was probably around $5,000. The defendant admitted to driving the truck. Was later identified. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed an extra vehicle from the driver's side. Made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. The officer then conducted a standardized field sobriety test, where he witnessed, sorry, Your Honor, the DIMS leaves off and does not show the standardized field sobriety test results. The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10. The defense said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
Or, I'm sorry, he did not. He did not. I apologize. We just have just a moment to see if I can.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. It also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. So I really can't make a lot of sense out of.
It's like the DIMS you're reading these like going through a drive-through, man. I mean, really, who's writing the reports?
Yes, Your Honor.
Over and over and over. I mean, really.
Trying to see if I can find anything else.
Case after case, we're just.
So Judge, things don't say it, don't say or is the results of this being revealed.
How on earth am I supposed to find probable cause when Mickey Mouse is writing?
I don't say. I don't know why it's not in the DIMS. Obviously, we didn't write it in here. We represent what is written in there, and so I curious now highly prepared.
Mr. Kubler, I'm going to find no probable cause in your case. Anyone? You know, every single day on the news, how many people die in our county because of a DWI? How many? Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out. This is not to say that they may not indict this case at a later time, but be whatever, just don't kill someone, please.
21, Serna Jonathan.
Good morning, Mr. Sarna. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir. On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer's supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there. Stop. Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
To stop. He refused to stop going towards the residence. In commands, there was a brief struggle where he was detained. I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's when this incident occurred.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and Squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what, so I was originally reading the summary. I'm going straight from the Dems down, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor.
I'm gonna find no probable cause in your case. Just be careful, man. When you get into a pissing match with,
I understand.
who's gonna win?
They are. I understand.
No.
Yes, sir.
All right. Hands,
All right. Sit down.
please.
Judge Fleischer determines that there is no probable cause to support the charge of interference with public duties. Under Section 38.15 of the Texas Penal Code, an individual commits the offense of interference with public duties by interrupting, disrupting, impeding, or interfering with a peace officer performing a lawful duty. While failing to comply with a law enforcement officer's instruction pertaining to physical conduct can constitute a violation of this statute under some circumstances, the command must be lawful, and the refusal to comply with the command must actually interfere with the police officer's performance of their duties. Here, the officers were focused on a suspect outside the residence, and Mr. Serna, who was not the target of the warrant, did not threaten, obstruct, or physically interfere with their movements. Although the officers instructed him to stay outside, the evidence did not suggest that his attempt to enter his own home created a safety risk or meaningfully disrupted the arrest operation. Without evidence that his behavior actually impeded the officer's duties, Judge Fleischer concluded that his conduct did not satisfy the statutory requirements for interference. Therefore, the state dismissed the charge against him the same day that Judge Fleischer found no probable cause. Our final hearing of this episode took place on April 25th, 2025, after Joseph Ramirez was charged with DWI on April 18th.
The council's approaching for page 15.
Okay.
Ramirez, Joseph.
Hi, Frank. How are you? You ready? Come on. All right. Good morning, Mr. Ramirez. Morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained, and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knees. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol. Anything, there's no accident. It just turned. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, he was coming from a tattoo shop and the police officer asked him, is he alcoholic because of the tattoo?
Is he what?
He just had a tattoo put on. That's the odor of alcohol.
Come on, man.
I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin? You're telling me that?
I don't know how it works, Judge, but I've never had a tattoo.
You're killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Okay, yeah.
That's all we have before he initiated the standardized post-mortem test.
Okay, that's not enough. All right, I'm going to find no probable cause in your case, Mr. Mears. We have enough death on our streets now. $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank.
Judge Fleischer concluded that there was no probable cause for the DWI charge because the only evidence that the officer had before conducting field sobriety testing was the alleged smell of alcohol on Mr. Ramirez's breath. Unlike a number of other states, Texas law requires police officers to have reasonable suspicion that a driver has committed an intoxication offense in order to request field sobriety testing. Because the DWI statute only prohibits driving while intoxicated, not driving after consuming any amount of alcohol, Judge Fleischer determined that the odor of alcohol alone was not enough to provide the officer with reasonable suspicion to require field sobriety testing, as there was no evidence that demonstrated that Mr. Ramirez was actually intoxicated. Case law and Article 38.23 of the Texas Code Criminal Procedure requires evidence that a police officer obtains through a constitutional violation, such as requiring field sobriety testing without reasonable suspicion, to be suppressed. Accordingly, because the results of the field sobriety testing and subsequent blood draw could not be considered, Judge Fleischer decided that there was no probable cause for the arrest, and the state dismissed the DWI charge the same day. At the end of the day, these hearings illustrate how essential it is for courts to act as a constitutional checkpoint in the criminal process. In each case that we reviewed, Judge Fleischer adhered to the basic principle that probable cause cannot rest on assumptions, incomplete narratives, or statutory elements that the state simply failed to establish. Whether officers neglected to communicate a lawful order, omitted critical facts from a DIMS report, misapplied statutes, or relied on evidence obtained through an unlawful extension of a traffic stop, the result was the same. The Constitution required more evidence than what the state presented. These rulings reinforce that probable cause is not a mere formality, but a meaningful safeguard against unjustified arrests, and that every charge, no matter how minor or routine, must be supported by competent evidence that satisfies the law. Judge Fleischer's decision decisions in these cases remind us that the rights of the accused do not yield to convenience, and that judicial oversight remains one of the most important protections. 3 different probable cause hearings held in the courtroom of Judge David Fleischer of the Harris County Criminal Court in Houston, Texas. A probable cause hearing is a proceeding that takes place soon after a person has been arrested, especially when the arrest was made without a warrant. Under Article 15.17 of the Texas Code of Criminal Procedure, the arrested individual must be taken before a judge without unnecessary delay. At this appearance, the judge informs the defendant of their rights and reviews the facts presented by law enforcement to determine whether there is probable cause to believe that the individual committed the offense. If the judge finds that probable cause did not exist for the arrest, the defendant must be released. Our first probable cause hearing took place on November 4th, 2024, after defendant Raquel Rodriguez was charged with driving while intoxicated on October 28th, 2024.
Yes.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Okay, this is page 20.
Rodriguez on page 25.
Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turns 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then,
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 alcohol.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
SFSTs were, this is for the dams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk-in turn, the one-leg stand. He also noticed that I think she took off her boots for the one-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accent here. There's no, is she a Spanish speaker?
DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per procedure for
Right, I
SFSTs,
get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right. Please take a seat.
Judge Fleischer finds no probable cause for the charge because he did not believe there were sufficient indicia of intoxication to authorize so-called SFSTs, or standard field sobriety testing. Because field sobriety testing extends the duration of a traffic stop, resulting in a longer investigative detention, officers must have reasonable suspicion that a driver has committed an intoxication offense in order to require field sobriety testing. Here, the evidence was limited to the smell of alcohol and Ms. Rodriguez's statement that she had consumed 2 drinks. The last of which she had finished 2 hours before driving. Accordingly, Judge Fleischer determined that there was no reasonable suspicion to extend the traffic stop to perform field sobriety testing. Under state and federal case law, as well as Article 38.23 of the Texas Code of Criminal Procedure, evidence that a police officer obtains through a constitutional violation, such as extending a traffic stop without reasonable suspicion, cannot be admitted into evidence against the accused in a criminal case. Therefore, because the results of the field sobriety testing could could not be considered, Judge Fleischer concluded that there was no probable cause for the arrest, and the state eventually dismissed the charge on February 24th, 2025. The next probable cause hearing we will review also occurred on November 4th, 2024. Defendant Keon Shaw was charged on October 28th, 2024 with fleeing a police officer in violation of Section 545.421 of the Texas Transportation Code, which makes it a misdemeanor offense for a driver to willfully fail or refuse to bring their vehicle to a stop when given a visual or audible signal by a pursuing police vehicle.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27th, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
The officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
anything illegal with that? You know,
I believe it would just be the speed limit would be the point at which the officer.
It's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure. Let's do this. I'm going to have them because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm going to find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, you know, trouble on your life. All right?
Yes, sir.
All right, man. Good luck.
Judge Fleischer finds no probable cause based on the fact that there was no specific allegation of how fast the driver was going in order to justify the stop in the first place. Although the Texas Transportation Code does not specifically require the stop itself to be lawful in order to charge someone with fleeing, the Constitution still applies. If the stop violated the Fourth Amendment or Texas law, then, as we discussed earlier in this episode, Article 38.23 of the Texas Code of Criminal Procedure requires that any evidence from it, including the officer's account of the driver not stopping, cannot be admitted in court. Under the Fourth Amendment, an officer may not stop a vehicle without reasonable suspicion based on specific and articulable facts that a traffic offense or other crime has occurred. In the 2005 case of Ford versus State, the Court of Criminal Appeals of Texas rejected a stop where the officer claimed that the driver was following another vehicle too closely without describing the actual distance between the vehicles, determining that a mere conclusory statement that a law was violated was not specific enough to provide reasonable suspicion. Accordingly, Judge Fleischer found that there were insufficient specific and articulable facts to find reasonable suspicion, and therefore that there was not probable cause to support the arrest based on the admissible evidence. The state dismissed the charge that same day. The final probable cause hearing in today's episode took place on January 27, 2025. Defendant Francisco Cerda was charged on January 22, 2025 with engaging in organized criminal activity in violation of Section 71.02 of the Texas Penal Code. This statute makes it a crime to commit or conspire to commit certain offenses with the intent to establish, maintain, or participate in what the statute calls a quote-unquote combination, which Section 71.01 of the Penal Code defines as 3 or more individuals collaborating in carrying on criminal activities. The statute applies to a wide range of offenses, including drug dealing, robbery, burglary, assault, murder, money laundering, and, as in Mr. Cerda's case, theft.
The last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wanted to touch on the law.
Is that C or an S?
It's the judge. Okay.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
My concern is, if you may, I want to just bring some, I guess, points of arguments to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
can you does mere presence impute criminality?
No, Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time.
But I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because 7102. A person commits an offense if, with intent to establish, maintain, or participate in any combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. and we have to
No,
decide.
he's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Judge Fleischer finds no probable cause because there were no specific allegations regarding Mr. Cerda's conduct besides being present in the stolen U-Haul. As the Court of Appeals of Texas in Amarillo explained in the 2000 case of Munoz versus State, in order to be convicted of engaging in organized criminal activity, the defendant must intend to participate in, maintain, or establish a group that agrees to work together in a continuing course of criminal activity that encompasses more than one crime or criminal episode. The court also held that an individual's presence during a single episode of criminal activity was insufficient to prove any agreement to jointly engage in illegality over the course of time. In Mr. Cerda's case, it was only alleged that he was in the stolen U-Haul, with no evidence supporting his potential involvement.
Uh-huh. I just don't get it. I do everything in my power to counsel over and over and over again. You are on probation in this court for a DWI, and you've picked up a felony DWI. Serenity now. This is not going to go well. I'm telling you that now. So this is what we're going to do. I'm not going to let this go because I just don't have faith. And so this is what we're going to do. Mr. Ronnie, I'm going to put a scram ankle monitor on you today. You will be given a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor so I know where you are at all times. And then I'd like to send her for a TRAS right now. And we're going to see what the TRAS says. And then we'll go based on, I don't know how we're best going to go forward. They may say inpatient treatment. They may say outpatient. I don't know. And I don't even know if I'm going to we're going to keep her on.
I understand, Judge. We're just not talking about it. We're just kind of stuck with because the probation was only for a week and a half. There's no other violations other than the new charge. So we're kind of stuck with, we obviously can't come in and play true to resolve it here. They can't really move forward on presenting a felony without the evidence. We don't have any work back. So I think that your proposal is the only thing we can do it.
So let's send it for, let's do that now. And then she gets a scram today as well. And let's set it for a week.
Okay.
If you consume anything, I'm going to go bananas on your bond. Do you understand? I have someone, I've set the bond at $2 million because it's over and over and over. I have no problem setting 5 to 6 zeros by the end of your bond. Do you understand? Come on. All right. We'll see you in a week.
This way, Judge, you said 1 week?
Yeah.
Okay. All right, Judge, our next is page 24, Moses. Walter?
I am so happy that you came. Good job coming today, Mr. Moses. I really, when you come to court, good things happen. And it just come back. Good things will happen when you do. All right? You're charged with criminal mischief. You're facing up to 6 months in jail. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, okay? Oh, please.
On December 29th, 2025, in Harris County, Texas, officer was dispatched to a criminal mischief call. Upon arrival, complainant pointed out defendant who was laying down on top of the hood of a car and was detained. Complainant stated she saw defendant running around the apartment complex, hitting and damaging other people's cars. All of a sudden, defendant ran towards her car, bumped into it, and started punching on her door. Defendant caused damage to the front driver's side door, costing about $300. Officer observed a video of the incident.
Okay. Do you mind, let's appoint him a lawyer. I'm going to have to take a seat in the jury box, and then I want them to converse, and let's see how we're going to go forward. Mr. Moses, I'm going to find that there's probable cause to go forward. You will not have contact with the complaining witness in this case. I'm going to appoint your lawyer today. Just go ahead, sign a reset with Victoria, then we'll have you take a seat in the jury box, okay? And then we'll talk here momentarily. No.
Page 24, Mom?
I wanted to talk to you first, and then we'll craft the conditions based on that. Good morning, sir.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Oh, come on in. Are your ears burning? Are your ears burning?
Yes, yes, yes.
Wonderful. Okay, are you ready? Ready? Let's roll.
On January 12th, 2025, in Harris County, Texas, on patrol, officer on patrol at 11:10 p.m. observed a motor vehicle hit his brakes multiple times and speed up and slow down. Officer then conducted a traffic stop and observed the defendant to have glossy eyes and slight slurred speech, and the defendant advised that he had a drink. Officer observed an open container, cup holder, with an empty container of alcohol. Officer asked what was in the tumbler that the defendant was holding. The defendant gave the tumbler to the officer, which was cold to the touch, 3/4 cold, and had a strong odor of alcoholic beverage emitting from it. An inventory search later found another container under the driver's seat and an empty flask. SFSTs were conducted, 6 out of 6 HGN, 6 out of 8 walk and turn, 3 out of 4 one night stand. The EIC was read, defendant consented to a blood sample.
I would venture a guess that it's damn elementary that you're not to have alcohol in the car while you are driving, and is a minimum of 6 days in jail if they prove it at trial. As a condition of your bond, you're ordered not to, well, I'm going to find that there's probable cause to go forward with your case, and I'm now placing a restriction on you, sir. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand, sir? I'm sending notice to DPS in Austin so that every police officer in the state knows if they pull you over and that car doesn't have an interlock, they're going to take you to jail. Do you understand?
Yes.
You will be randomly tested for drugs and alcohol as well. If I find that you're using, likewise, you will go to jail. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you, I'm going to revoke your bond. Do you understand?
Yes, sir.
All right, I'll have you sign a reset with Victoria. We'll have you get with Roxana.
Where
And
do
then,
you talk to get that interlock right?
all right, good luck.
Right this way. All right, Judge, page 27, Palomino, come on up. Right now.
Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 11th, 2026, Harris County, Texas, officer observed several vehicles traveling at a high rate of speed on US 290. Officer observed defendant's vehicle position itself next to another vehicle. Both vehicles slowed to approximately 50 miles per hour before rapidly accelerating while side by side in an attempt to outdistance each other. Officer estimated both vehicle speeds to reach approximately 100 miles per hour, as the officer was traveling 92 miles per hour with not being distance on them. Traffic stop was conducted and officer made contact with the defendant. who was the driver, as well as a passenger.
Okay. License?
Eligible, Your Honor.
Sir, I'm going to find that there's probable cause to go forward with the case as a condition of your bond. I'm ordering you not to drive in this manner again. If you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you. Living in a city as big as Houston without the ability to drive blows. Do you understand? Not only that, the legislature's made it very easy for DAs across the state to seize and take cars from individuals who participate in these types of actions. And I've seen it where they've taken cars, $50,000, $75,000 cars permanently. Do you understand? We are going to reset your case to give you time to hire a lawyer. I'll have you go. Victoria, sign a reset. We'll have you take your seat in the jury box. I'm going to get your bond conditions. Once you sign them, at that point, you'll be free to go. No racing, street takeover, donuts, etc.
Yes.
Please.
Go ahead. All right, Judge, page 29, South.
Good morning. Sir, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 11, 2026, in Harris County, Texas, officer was dispatched to an academy in reference to a theft. The manager reported that defendant had stolen a speaker valued at $250, causing all points of sale without rendering and fled the store on foot. Officer located defendant matching the description given by the manager. Defendant gave commands, or officer gave commands to defendant to stop, but defendant ran away. Officer pursued defendant on foot for approximately 50 feet until defendant stopped and complied. Officer observed the speaker partially exposed in defendant's left side jacket pocket. Defendant stated that somebody had given it to him earlier. The academy manager confirmed that defendant was the one who committed the theft.
Sir, I'm going to find that there's probable cause to go forward to the case as a condition of your bond. You're ordered not to go to any academy,
Yes.
not to go to any academy whatsoever for any reason. If you do, I will revoke your bond, put you in jail. If you pick up a new case, likewise, same thing will happen. Do you understand? Do you have the ability to hire a lawyer? We will give you time. I will have you go sign a reset. We'll have you take a seat in the jury box and get your bond conditions. Once you sign them, at that point, you'll be free to go.
All right, Judge, top of 35, Torres, come on up.
Your Honor, those are state's conditions.
Please, yeah, no going to any account. Sir, you are charged with driving while your license is suspended. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 12, 2026, in Harris County, Texas, officer conducted a traffic stop on a vehicle for its R registration. Officer made contact with the driver. While conducting a driver's license and persons check, officer discovered that defendant's driving status was not eligible. Defendant stated he knew his driver's license was not valid.
What was the stop for again?
It was a stop for an expired registration.
Got it. Mr. Torres, I'm going to find that there's probable cause to go forward with the case. As a condition of your bond, I'm ordering you not to drive any vehicle whatsoever for any reason. And you will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I'm telling you now, I will go bananas on your bond. Do you understand me? You cannot justify getting into a car and driving for any reason. I don't care what you have to do in this life. Work, food, school, church, nothing. Do you understand?
It looks like counsel barely filed the attorney report.
On this gentleman?
Yeah, about 20 minutes ago.
Okay. So let's just wait for counsel to get here to do the reset. Let's go ahead and have him sign conditions now.
So the no driving affidavit.
Yeah, that. And then can you file also no driving, please?
Yes, Your Honor.
All right, come on up. We'll have you sign this, and then we'll have you wait for your lawyer to get here.
All right, Judge, the last one is on page 37. Worthy, come on up.
Good morning. You were charged with assault and bodily injury. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 9th, 2021, author discussed in reference to assault. The complainant stated that the defendant was helping on her kids so that she could enjoy her son's birthday today. The complainant stated the defendant was causing disturbance by arguing and name-calling her husband. The complainant stated after the defendant left the residence along with her husband. The complainant stated her daughter later notified her that the defendant, her son, and her boyfriend confronted her husband outside. The complainant stated she went outside and used the situation from escalating by telling her husband to come inside the residence. The complainant stated while talking to her husband, the defendant approached her, confronted her face to face. The complainant stated while she was confronted, the defendant pushed her to the ground, causing her to feel pain and discomfort.
So it was a push to the ground.
Yes, Your Honor.
Okay. I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person, not to be in possession of any weapons. You understand? Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. We'll take a look to see whether you qualify. I need to know everything about you, whether you work, how much money you have coming in, and I'll take a look to see whether you qualify. Deputy Williams will give you an application. You can go hire a lawyer if you don't qualify. Yeah. So, well, let's see. I mean, I need you to fill out an application. We'll take a look. And Deputy Williams will give you one. Do not leave until you sign the bond conditions, though, please. Okay. So no contact, no. Hey. Ready? Hey.
I have Mr. Henry Spencer on today for a bond violation report.
Come on up. Tell me what's up.
I was received a report from Tree Crawl about late unapproved exits and entries. Looking at the GPS, it's hitting a gas station that's right behind the apartment complex. They're, I think, on 4 separate days. One, they were able to call him and he let them know he's in his backyard, and they got the unapproved entry after that. But it looks like all of them are about 20 minutes, 30 minutes. It's just hitting.
One is at 11, past 11:15, you know?
Yes, sir.
And Aaron, as much as I appreciate you, it's over and it's over and it's over. And we're now on our 4th bond violation. You are not getting the picture, sir. Over and over and over. I have bent over backwards not to put you in jail. But this is your 4th, and you will now go to jail. I'm revoking your bond. I'll set it at 10,004 because this is the 4th one, and then just let me know. He'll auto-populate until tomorrow's docket. So, yeah, please. Thanks, Aaron. Hey. Hi.
I didn't want to interrupt.
That's okay. What's up?
I have Mr. Defendant Castillo on the docket today.
Okay.
Yes.
He's in jail?
No, this is on bond.
Okay.
And we had entered into a 1-year PTI for him to pay for 17 amount. He's well on his way, Judge. He's has a balance of 6,900. He has been making payments. He has even made payments when he's like locked out. So he's on his way, and he finds he has family members that help him every now and then, but he's taking.
Okay, give me 1 second. Let me. How much is he paying?
He's paid $3,795.
Great. And two's left?
Yes, 2,997.
So when's the next payment? And how much does he have left?
15. In restitution, he has 24 left. And I would.
And how much is left in time as far as?
That's it.
Okay, so I would say he at least do, I mean, 500, 600 a month, right? So let's do another status, probably like 2 months prior to termination, and let's see how far he is. Okay?
Sounds good.
Yes, okay.
He's a very hardworking kid.
Great.
Good job, he's on the bicycle.
As soon as it's done, then we'll, right. Yeah, okay, thanks.
Jeff, how long ago was that?
Yeah. But do like 3.5 months. Roxana, on the one that picked up with the DWI third week request for illegal. Hey, what's the last name? How's it going? He did the TRS? Oh, they're sending him now.
Yeah, he came in this morning from court.
Great. So we'll give you like 2 weeks to finish everything up. Yeah? Okay, for sure. So if they're off docket, what I need you to do is let her know. We'll put them on docket and make sure your clients are here so we can address it then. I don't grant it off docket because then they get here, we never knew about it.
What about the case warrant status?
Okay, then I'll grant it. If it's in warrant status, then yeah. No. Just have them put it in the queue. Yeah, I'll sign it. If it's in warrant status, for sure. Is she here?
Yes, Jeff, in the box.
Come up, ma'am. Is that her? Hold on. No, that's her. In the brown, right there. Miss McDougal? McDougal? Yeah. Hey, can I borrow one of you guys? Sean, I think it's yours. Can I give you a case number?
Yes. Great.
2260091.
26009.
Yeah. It's hers. Oops. Sorry. Is it M or N? The letter where you guys switch off.
It's like the first half of the M, so it's.
Oh, for the love of Pete. I mean, really.
It's so.
Come on. Okay. Ma'am, you're charged with criminal trespass of a habitation or shelter. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On January 5th, 2026, officers dispatched an alarm call at 5503 Pebble Springs Drive in Harris County, Texas. Complainant stated he could see defendant on a live feed. Complainant stated he could see defendant in the garage, then stated he observed defendant in the backyard. Complainant was not on the scene. Officers made contact with defendant who stated she lived at the residence. Complainant arrived on scene, confirmed that it was his residence and that defendant did not have permission to be there.
So no relation or anything?
No, it's not evident from the DIMS, Your Honor, that there's a relation.
Any prior criminal history?
Yes, Your Honor, she has an extensive criminal history.
Extensive criminal history.
She has 3 prior ADIs, a prior criminal trespass, 2 prior criminal mischiefs, an assault of a police officer, a terrorist threat.
Any Berghabs or anything like that? Berghabs or anything like
No
that?
Berghabs.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm now going to place a GPS monitor on your ankle so I know where you are at all times. Your case is in warrant status now because you failed to make court. I will reinstate your bond today. You get 1. If you ever fail to appear again, I will revoke it, and this time I will put you in. Do you understand me? Do you have the ability to hire a lawyer? I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Ma'am, do not go back to this house. Do you understand? Do not have any weapons. If I find that you violate these conditions, if you pick up a new case, it's not going to go well between us. Do you understand? I'm going to protect my community at all costs. I don't care who you are, how old you are, anything. Do you understand?
Yes, sir.
All right, come on.
Yeah.
Balance.
Your Honor, those are pre-trial conditions.
No, I'm gonna have her monitored, so you don't need to. She'll be. So a total of one, two, 4 cases are being dismissed
Yes, Your Honor.
in exchange for your plea on the 5th case. How was jail?
Jail.
You know, we have it for a reason. You know what happens when you endanger our community. It's there to not only protect, but to also teach and have you learn that actions have consequences and you cannot you cannot continue to do what you do and expect good things to happen. Do you understand?
Yes, Your Honor.
And the thing is with your history now and the way it looks, anytime you come in contact with the laws, it's probably not going to end well. You understand?
Yes, Your Honor.
The agreement that you have worked out is 1 year in jail, and we are giving you credit for the 83 days that you have done. You need to understand that this will reflect as a conviction on your record. It will be there for the rest of your life. Even after you die, it's still there. There is also an affirmative finding of family violence. What that means is that if you ever pick up you can never pick up another gun, ammunition. If you ever pick up another one of these cases again, from now on, you are looking at a 3rd-degree felony. If you thought this was bad, start reading what it's like in prison. I was reading this article the other day, and they were detailing the life of a person in prison now who is doing life for some capital case. And they were a bunch of groups like the ACLU and all these other groups concerned because of his mental deterioration of this person who's sitting in prison now, where he literally sits in a cage, a 9-by-12 cage. And I promise you, he sits there 23 hours a day, 7 days a week. The only time they let him out is in a cage so he can get just a little bit of exercise and shower maybe a couple times a week. And while he's in that cage, he has about 10 guards that surround him the entire time. He is literally sitting there like a freaking caged animal. And his mind is now deteriorating so bad that he's not himself anymore. This is what happens when you go to prison. It's not a pretty sight. Do you understand?
Okay.
So please, it's not a joke. And with this, you are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this plea of guilty, like I said, it will go on your record. It will be there forever. There is also the affirmative finding of family violence. So if you pick up another assault like this, and it doesn't have to be a drag down where you beat the hell out of someone, grab someone's arm enough and squeeze it to where it hurts, you'll be facing up to 10 years in prison next time. You understand?
Yeah.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty.
Morning, Judge.
Hey, sorry about that. I couldn't see you.
No worries,
You
sir.
just want to reset?
No, Judge, we're here for the dismissal today. The prosecutor had stated that they would adjust the restitution.
Give me, hang tight. Let me find out.
Yes, Judge.
Paper.
And Happy New Year, Judge.
Hey, you too. Did you email them? Anything?
Yes, Judge, I emailed Sean McLaughlin,
Okay.
November
Did you
19,
wanna take
November
a look,
25th.
Did you get everything or no?
Yeah, we have a restitution issue. I'm just gonna say no restitution. And we'll do
A what?
We'll do 80 pounds.
If you, an anti-theft class, they'll kick it. Okay?
No restitution.
That'll be great, sir.
So you want a regular reset, like 30 days, or how long you want?
As soon as possible, Judge. How long is this class, if I may ask, please?
I don't think it's gonna be a couple hours. As soon as you email it to me, we can dismiss it on docket.
Yeah. It's up to you how long it takes. Just have them look it up and they'll take one.
Okay, actually, Judge, if it's okay, we're happy to make the payment today and just get it dismissed.
Well, no, let me give you some time just in case. You never know what happens in life. How about like a week? You want a week?
Sounds good, Judge. Thank you.
To let you know why I'm not doing it, the bar is giving us.
Don't justify. Just don't worry about it. Okay, a week, bud. All right. Do you
And
want to
Judge,
do
may I
like a week
please-
from today, next Tuesday?
That'd be great, Judge. And may I please ask which prosecutor I should get in touch with to follow up?
Send it to who you were sending to before.
Okay, because I haven't received any responses from Mr. Sean.
Hi.
Hi, good morning.
Okay. What's your cost number?
2009-8314.
Okay.
He's not here today, Judge, but, it looks like you ordered, they have the interlock device. You know, our fifth round on January, I know it's just probably still impounded, and says he doesn't have a money to get it out. So I think they did end up on the violation report, but I wanted to approach it with the, I think, and.
I was just gonna make sure. And then I'll get.
So let's do this. Let's put him on docket for tomorrow. He's got to be here so I can talk to him and admonish him. You know, he was supposed to get it that, 18 days ago. Here we are on the 20th. Had we not reached out to him, he would have never done anything. You know what I mean?
Well, he knows what I do on the night, so, and he asked me last week, but I was trying to Friday.
That's okay. So let's put him on for tomorrow and then let him know he's got to be here and then we'll fix it.
Okay, understood. Thank you.
Yes, ma'am. Hey, what's up? Last name?
J-A-H-A.
Okay.
And I spoke with the state and we're still using the MDTs in the tow slip. It was marked complete, so they're just reaching out to the admin to see where it is. It's not discovered.
So let's do a 10-day discovery setting. You've got 10 days to get it. If you don't get it, then you know how it goes, huh? I mean, really, we're nearly at 180 days and we're supposed to have it. So, all right, 10 days. Yep. Hey, ready?
Yes.
Hey, what's up, man? What's the last name?
It's Kristen Cannon, top docket. 2577. 347. We're set February 4th. I just need about 3 weeks. I think it depends on where she is. She's about to have some surgery, so we need some time to get her ready.
File a motion for continuance. I'll grant it. Why?
I'm just asking for 3 weeks. It's off docket.
Oh, are you set for trial?
No.
Oh, I thought you were set for trial.
No, it's just.
Oh, no. I'm sorry. I thought you were set for trial.
I did not clarify that. Sorry.
I thought you said we're set.
No,
I assumed that.
we are set February 4th, but it is kind of at the end of the road, but it's not a problem.
Okay. All right.
Good?
Okay. I thought you were set for trial. In that case, I would want a motion, but.
That I get.
Okay, sure.
Thank you.
Absolutely.
Oh, hey, I see something there. This is his.
Hey,
Judge, how are you?
Muncie, I'm granting it for you.
Thank you. I appreciate it.
Get with Ramona, okay?
Also, Judge, as far as the case goes, I got an email from Caitlin this morning
Can't hear
saying
you.
that
It's too loud in here, man.
Okay.
Just get with Ramona.
Okay. Sounds good, Judge.
Okay, man.
All right. Thanks. Bye. Oh, Judge, you want her to, she just waits there, right? Then you'll give her a copy.
I can't hear you, Brad.
Okay. No problem. I'll email her.
Have fun, man.
All right. Thanks.
Hey.
Mr. Ramirez.
Okay. Good morning, Mr. Ramirez. Mr. Ramirez, you were placed on probation for failure to stop and give information. Failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. It looks like it has not worked out. So now you want to accept this agreement. What you need to understand is that I'm now going to revoke your probation, going to sentence you to 60 days in jail. I will give you credit for the 21 days that you've done, but you need to understand that this will now reflect as a conviction on your record and it will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail. Do you understand? You are giving up the right to a trial. I'm sorry. Is it true or untrue that you violated your probation? I'm going to find that it's true. I'm now going to revoke your probation, sentence you to 60 days in jail. I will give you credit for the 21 days that you've done. Good luck to you, sir. Thank you. Hi.
Good morning, man.
Coming up. Who's the last name?
Bones,
Got it.
WAS. I have a problem with you.
I got it. So it's 97 days old. You just want to reset?
Actually, Judge, I thought a motion for the Bones case. Non-payment.
No. Is the person here?
Yes, Mr.
Come up, sir.
What was the good?
Morning, Your
It's not a good morning. When your lawyer's upset with you, that's not a good morning. What are you doing with yourself these days?
I'm take care of my daughter, full-time father. Find her job. Once you get she's trying to get back to Florida.
When is the last time you ever had a full-time job?
Oh, that before I got arrested in jail. I mean, in court. So that's not my food.
Oh. Council, where we at?
I need you to fill out an application for me, Mr. Bounds Carter. I'm going to set you 2 weeks from today. You best do everything in your power, as many applications as you can, because you don't get to sit at home and play Xbox all day while the people of Harris County are paying for you. It's time for you to get a JOB, full time, and you will be tested upon your return. Do you understand? 2 weeks. Deputy Williams, can you give an application? All right, I'll grant your motion.
Thank you, Judge.
Okay, yes, thanks for coming early.
Good morning.
Hey, coming up. What's the last name? Okay, what's up?
So Judge, Mr. Hunter was released at bail on Friday. He had nothing to do with his probation. So I understand that he checked in this morning. I was actually able to get a hold of him on the phone. He's number from
He's not here.
he has left.
It's been like this for the last 2 years, where he does what he wants to do. Just
Judge, I will just state for the record, I have been informed that his mother had a medical issue that required him to leave court early. He felt that he was headed to the hospital now.
I mean, this is probably his 8th failure to appear, give or take. Yeah. So it's at 15,003 now. So let's do, I guess, 25,004. Maybe that'll get it. No. This is his 8th failure to appear. His I can't tell you how many bond violations, and I've literally extended him courtesy after courtesy after courtesy. Filed a motion to revoke. He doesn't even, sorry, because at that point now we'll just continue to be enabling his behavior, and I can't just continue to do that. So, I guess we'll just see what happens. Okay, thank you. Hey.
You ready?
Yeah. What's the last name?
This is down to $8. Ready for a case number?
Yeah, hold on.
It's a Thursday.
Oh, you want to do it today?
No, we're trying to, get it off that reset from you because the DWI contract is not ready yet and it's set for Thursday.
Where are you at in the process?
It's not bad, it's a port.
No. Where are you at in the process though?
Oh, we're supposed to have the contract ready by Thursday.
Okay.
But I reached out to Henry, he wants a letter from his employer to get a portable device, but my client can't get a letter from his employer because if they know they can get charged with
Okay,
it.
so, but why would they want to?
Because we're asking for a portable device now.
Oh, okay. So I'm assuming it's old though, right?
It's a June.
How long do you want?
Just a week.
Okay, fine. But if it's not done by then,
Yeah,
that's it.
We're trying to get it. I'm trying to get it.
All right. Okay,
Thank
you got it.
you.
Hey, hi, Ellen. How are you?
Just
You have someone on docket today?
I do, Judge.
What's last name?
Thomas, Don Thomas is in custody.
We have 130 on the docket today, so it's like this thing is about as thick as the Bible. So he picked up a felony.
Yes, Judge, that's fine.
Let's see.